Today we'll dive into the gag order that was issued in the George Floyd murder trial, and we'll talk about why the defense attorneys for the 4 former officers are claiming that this gag order unconstitutionally violates their client's free speech. I'm Attorney General. I break down legal subjects in ways that everybody can understand. If you're not a lawyer but enjoy thinking like one, I encourage you to click the subscribe button. Now let's go ahead and get started. On Monday, July 13th, the defense attorneys for the 4 former officers in the George Floyd murder trial filed a motion with the court asking the court to rescind an earlier order from last week that prohibited the attorneys and the other parties related to the case from publicly discussing the case. So last week, Judge Cahill, the presiding judge in this case, issued a gag order. The gag order prohibits any attorneys or parties related to the case from publicly divulging any opinions, strategies, plans, or potential evidence. The gag order came after 2 of the defense attorneys spoke to the Star Tribune in response to a motion to dismiss the charges against one of their clients, Thomas Lane. Judge Cahill says that his order is an effort to prevent the tainting of a potential jury pool. So let's discuss what that actually means. Eventually, there will be a jury that is going to decide the fate of these 4 officers. And in the best interest of justice, we want this jury pool to only consider the evidence and the arguments that are made within the courthouse, not things that happen outside of it, not things that happen in the press. What Judge Cahill's concern is that certain thoughts and opinions expressed by the attorneys or other people related to the case that are expressed outside of the courthouse and before trial may find their way into the hearts and the minds of the future jurors of this case. It should be noted that gag orders are pretty rare. You don't see them in every case, but then again, this isn't the type of case that you see all the time. The defense attorneys in this case for the former officers are essentially arguing that it's too late to prevent the tainting of the potential jury pool. There has already been an incredible amount of pretrial publicity. We've all seen it. So they're saying we should be allowed to give our side in the public domain to then balance out any prejudice that may exist in the minds or the hearts of these potential jurors. I want to know what you would do in this situation. If you were a juror on this case, would you be able to come in with a blank slate to forget everything you've heard and seen in the past about this case? Or do you think you've heard and seen enough and you've already made up your mind? Leave a comment below and tell me exactly how you feel. I'm Attorney General Keith Ellison, and this is not legal advice.